Well, hello, folks out there in YouTube land. Got a big show lined up for you today. All right, folks, Tennessee and Virginia are suing the NCAA, and it is so on.
Okay, all right, we got served. So now, I guess, it's on.
Oh, yeah, it couldn't be more on. Yep, NCAA is coming after Tennessee, and actually Virginia, the state of Virginia, has joined the state of Tennessee in a lawsuit against the NCAA. This was a mistake. They should not have gone after the Vols over this, especially over NIL. This is a school that totally cooperated with them months ago in a case where they took blame for the mistakes. And they worked with the NCAA to the point they even praised them. But now they want to go back and retroactively use rules that they made up 10 months later. Oh, well, you broke these rules. You may have followed the rules where they were and the guidelines, but we've changed the rules, so now you broke the rules, which is absurd. And here's the thing about the NCAA. They keep losing in court. You want to know why they keep losing in court? Because what they're doing is not lawful. See, they think they can write this little booklet out of guidelines or their little handbook of rules and regulations. Here's the problem. If those don't correspond with laws in the states and in this country, guess what's going to happen? You're going to get the crap smacked out of you, okay, NCAA? And you want to know why it's going to happen? Because it's already happened twice. It happened to you on NIL. You got the crap smacked out of you in California on that one. And then the Supreme Court ripped you. And then secondly, you got ripped on the transfer portal because you wanted to not allow people to transfer more than one time. And the courts went smack. And see, you don't learn. You don't learn. It takes 3 smacks, I guess. It takes the 3rd time for you to learn.
Snap out of it.
And you're getting ready to get it the 3rd time. And this is the lawsuit right here from the state of Tennessee, our attorney general, that has just been filed. And I've been pouring through it. And I'm going to tell you right now, you got problems. You got problems, NCAA. And we're going to spend a little bit of time on this. But first, I thought I would give you just a little taste of what a lot of people are saying about the NCAA and how they feel about this case. And this is on X. It says, J.D. Piquel says, this is not Tennessee versus the NCAA. This is college football versus the NCAA. Senator Marsha Blackburn says, good on Tennessee and UTK Knoxville for standing up for the rights of their student athletes. I'm calling on Senate Commerce to take this issue up and to hold the NCAA accountable. Barstool SEC said there is not a fan base in the world that is built for the challenge of finally abolishing the NCAA once and for all, like the Tennessee Vols and Vol Twitter. The NCAA has no idea what they've gotten themselves into. All right, folks, now we're going to get into the actual court case. And this is what Virginia and the state of Tennessee has filed against the NCAA. And I'm going to get into the minutia of this. Now, I'm going to try to briefly go through it. It's 20 pages, so obviously I'm not going to go through every page. But I'm going to hit the high points. I've already done this by hand, so I know where I want to go with this. So this is not going to take a ton of time. But if you're somebody that can't stand looking at a contract or that bores you in any way, humongous, let them know.
Just walk away.
Just walk away. I understand. Or you may just want to skip past this. I'll probably spend 3 or 4 minutes, maybe 5 on it. But I think it's riveting. I mean, I've been all in this, and it is a great lawsuit. They're going to lose bad. And I can tell you what they pretty much told them.
It's your last chance to walk away. Remember, you wanted this.
Yeah. You wanted this, NCAA. Well, now you're going to get it. Starts out, it says, the state of Tennessee and the Commonwealth of Virginia bring this antitrust case against the NCAA. The NCAA has started enforcing rules that unfairly restrict how athletes can commercially use their NIL at a critical juncture in the recruiting calendar. These anti-competitive restrictions violate the Sherman Act. You're going to hear a lot about the Sherman Act.
Oh, my baby. Sherman.
Harms the states and the welfare of their athletes and should be declared unlawful and enjoined. It talks about how the NCAA runs a business. The problem is their business is a monopoly. They control college sports, and they've done it forever. It says that all changed in 2021 when the U.S. Supreme Court decided Alston, which was the case, said that case rejected the NCAA's long-held arguments why amateurism rules are exempt from the Sherman Act. They are no longer exempt from it, especially when it comes to compensating college athletes, and they are subject to the rule of reason and often plainly illegal. The court thereby affirmed a decision invalidating that rule. Enter NIL. The NCAA finally understood that it could no longer ban college athletes from earning money, and various states started passing rules. And it was to protect prospective current college athletes and their opportunities. And what the plaintiffs are saying, which is Tennessee and Virginia, is that the NCAA is interfering with athletes' ability to earn NIL compensation, because they are. It says the NCAA is thumbing its nose at the law. After allowing NIL licensings to emerge nationwide, the NCAA is trying to stop that market from actually functioning. It talks about how it bans prospective college athletes from discussing potential NIL opportunities before they actually enroll. So they have to enroll, then talk about NIL. That's ridiculous. Nobody's going to do that. It says the NCAA approach restricts competition amongst schools and third parties to arrange the best NIL opportunities for the athletes. The NCAA bans the use of NIL contracts as a recruiting inducement, and saying they cannot negotiate NIL agreements before they commit to a member institution. They must commit, enroll, or transfer without understanding their NIL opportunities. That's insane. That's insane. That's the rule of common sense that they're breaking. It talks about how a federal court in a lawsuit joined by Tennessee and Virginia, another one, recently stopped a similar maneuver by the NCAA, where the NCAA tried to restrict players from entering the transfer portal twice. They, of course, lost that because that was a direct restraint on trade. That breaks the Sherman Act, which is a federal law. Hello? Stop breaking the law.
Stop breaking the law, asshole!
Then they asked the court to declare unlawful and enjoin the NCAA's NIL recruiting ban and allow this market, which already exists, to function fairly and competitively. It says without relief, the NCAA will continue to deprive plaintiff states' athletes of information about their market value, which is absurd. Then it states that the NCAA, seeing the writing on the wall, they reacted to the decision about Alston to allow athletes to obtain NIL compensation. But despite allowing that, the NCAA has endeavored to impair their ability to obtain NIL compensation. Put simply, this suit involves admitted horizontal price fixing in a market where the defendants exercise monopoly control. The NCAA is a monopoly. It says these anti-competitive restrictions deny athletes access to the free market, again in the name of amateurism. So they were trying to go back to something they've already lost in the Supreme Court. Tennessee also passed a law after the Supreme Court passed one. The Tennessee NIL law protects athletes' ability to earn compensation for fair market value. And it talks about how the universities cannot interfere with an athlete's decision to earn NIL compensation. So the universities can't get in their way, and the NCAA sure as crap can't. The Tennessee law prevents athletic associations, including the NCAA, from interfering with a college athlete's ability to earn NIL compensation. Virginia also has a law very similar that protects athletes when they want to make money through NIL. The NCAA's NIL policy imposes unlawful restrictions on the market. It says the interim policy that the NCAA bylaws interfere. It says the NCAA also classifies collectives as boosters and thus prohibits all NIL discussions between collectives and college athletes prior to committing to a particular school. That's where they're going to get their money. So you're not allowing them to talk. Again, you're breaking the law. Now we're going to get into the most recent NIL crap that they've been going after Tennessee and other programs. They've gone after Florida State. They nailed them over a guy driving a guy to an NIL meeting, which was ridiculous. Florida State lost 5 scholarships. So 5 people won't get scholarships because of that nonsense, that stupidity of, oh, well, you drove the kid to the meeting, so therefore you're in trouble. He wasn't even in the meeting, and the player was in the transfer portal. It's absurd. It says, until now, the NCAA has not meaningfully enforced its mishmash of guidance, which has been constantly in flux and never clear. This month, however, it's talked about how they went after various schools. It says, by restricting NIL discussions for prospective college athletes, the NCAA's current policy restricts schools from competing to arrange NIL compensation. Once again, restrictions. You can't do it. Here they brought up the Florida State assistant football coach violated NCAA's when he facilitated impersonal recruiting contact for discussions of an NIL opportunity with the collective. So, yeah, you can have NIL money, but you can't really talk about it. The NCAA thinks this is Fight Club.
You do not talk about Fight Club.
It's not Fight Club. It says, and reports surface that the NCAA is now threatening the University of Tennessee with imminent enforcement actions as well. It talks about the letter from Chancellor Plowman to President Baker. It says the NCAA's newfound interest in NIL enforcement actions highlights the suddenly urgent nature of the issues raised in the complaint. In other words, we need relief now. Now here it's going to talk about how the NCAA has violated the rules.
Again.
Has violated the Sherman Act. The NCAA has entered into an illegal agreement to restrain and suppress competition in the relevant markets through the adoption and enforcement of NIL recruiting ban, which prohibits athletes and collectives from open and transparent interactions. These restrictions fail the rule of reason applicable to antitrust claims. It says the NCAA and its directors, employees, agents, etc. have entered into an illegal horizontal group boycott of prospective college athletes who contract and negotiate NIL. It says the NCAA's illegal contact has just begun in earnest and will continue to impose immediate, irreparable, and sustained harm on college athletes, institutions, and consumers of college athletics, unless an injunctive relief is granted. They want an injunction, an immediate one.
I'll slap an injunction on them so fast it'll make their head spin.
And now they're talking about interstate commerce. The NCAA and its member institutions' anti-competitive acts were intentionally directed at the United States market and had a substantial and foreseeable effect on interstate commerce. That's boom. Yeah, you can't do that. The TRO, which stands for Temporary Restraining Order, and the preliminary injunction, then permanent injunction barring the NCAA from enforcing its NIL recruiting ban or taking any other action to prevent prospective college athletes and transfer candidates from engaging in meaningful NIL discussions prior to enrollment, including under the NCAA's rules of restitution. They also want the plaintiff's attorney's fees, costs, and expenses paid for by the NCAA and any other such relief the court may deem just and proper. And it's signed by Jonathan Skrmetti, Attorney General of Tennessee, and Jason Myers, Attorney General of Virginia. So hopefully you made it through that. I tried to make it as brief as I could. They're going to lose. They're going to lose this. They've come in and they've tried to change the rules after the fact. It's all been ridiculous. Plowman said it beautifully. 10 months in the future, you change the rules from 10 months in the past, which you cannot do. That's just absurd. No court's going to allow that. No judge is going to allow that. What you should have done was set up reasonable rules, got with some attorneys, not fought this in the Supreme Court, and set up reasonable NIL rules so kids could make money. But you didn't want to do that. You fought it all the way to the end, and then you got caught with your pants down. Then you started throwing guidelines out left and right, willy-nilly, which were absurd. A lot of them were contradictory, didn't make any sense. And you're trying to stop people from making money. That's what you're doing. You're trying to stop athletes from being able to make their top dollar. That's not how a free market works. That's not how the United States works. It isn't. It's not how the state of Tennessee works or Virginia or any other state.
I'd unfriend you.
That's not how it works. That's not how any of this works.
You cannot stop athletes from making money. And I know you want them to be amateurs. I know you're mad you lost the Supreme Court hearing and they ruled against you. I get all that. You're still mad about that. You just lost the transfer port ruling. You just keep losing, you keep losing, you keep losing, and you keep fighting. And you're going to lose this because that's what you do. You go to court, the judge looks at it and goes, that's clearly a violation, smack. But you're going to keep doing it. You're going to lose this, and you're going to lose what teeth you got left. I'll just go ahead and tell you, you're not going to have any teeth left. You're going to have no ability to do much of anything because schools are going to ignore you, states are going to ignore you. They're just going to pass laws, which they've done, which don't allow you to do the things you're doing. You've got Plowman against you, who cooperated with you to the point you praised her. Now she's dead set against you. You've got UT's athletic director. You've got the state attorney general. You've got the state attorney general of Virginia against you. And look, nobody's rooting for you. I'll just go ahead and tell you. All the other schools know you're coming for them. You're going after Florida. You're going after Florida State. Florida's going to join in. You know they will. That attorney general down there can't wait to rip you. It's only a matter of time, and every school out there. Do you think there are schools in Texas that didn't have some so-called breaking of rules like Texas A&M and all of that stuff with NIL? They're going to go back and retroactively hit them. They're going to hit every school because the rules were impossible to follow because they weren't lawful. They weren't legal. They were mishmash. They wrote them down in their little guideline book and said, oh, this is the law. No, it's not. No, it's not. Not if that goes against the laws of the state or the United States. If it goes against that, that guideline doesn't mean squat. And the fact you have to go to court to find that out, again, how many times you got to lose? How many times you got to lose and look like a fool? I guess you're just going to have to keep learning the hard way. Reacher was right. You asked for this, you're going to get it. All right, folks, I just wanted to break this down for you. Hopefully I did a good enough job for you. I am not an attorney. I don't play one on TV either. But anyway, I did want to go through that. They're going to lose. I am not worried about this one bit. I think the NCAA made a terrible mistake. And they went after a program that cooperated with them fully. And here's the thing. I accepted the punishment we got over the Jeremy Pruitt thing. Have you heard me complain about that? No, we deserved what we got. The fact that we cooperated is why we didn't get the bowl ban. I would have been mad had we gotten a bowl ban because we cooperated. But we deserved to lose 25 scholarships and to get a $12 million fine. I'm fine with that. We broke obvious rules. But this NIL crap, no, we didn't break any rules with that because you can pay a player to play football or basketball. And the Supreme Court stated that very clearly. And you can make all the little guidelines you want. They don't mean squat. The court's going to smack you down. If you like this content, be sure to hit that like button. Lets me know to continue to cover this nonsense, this ridiculous crap that the NCAA is trying to throw on our team. It's absurd, and they'll be coming after your team. Don't you worry. You can sit here and roast marshmallows on this all you want. They'll be coming after you for NIL. You need to hope we whoop their butts so you don't have to. And if you haven't subscribed, it's on your right, my left. Hit this little button. I'd appreciate it. Cost you nothing. Help you get my videos and all my rants. And right over here's the most recent video. YouTube thinks you'll enjoy. And we'll see you next time on Sports Talk J. Maybe I'll calm down, but I doubt it.